Good afternoon, sir. Can you see and hear me?
Can, thank you, yes.
Thank you very much. Good afternoon, Mr. Atkinson. Can we go back to page 28 of your report, please?
Yes.
So on the screen, that's, thank you, page 28. I think we'd got up to D. Is that right?
Yes.
And so in this chronological run of policy documents relevant to the issue of separation of functions and separation of decision making, you turn to the Royal Mail Group prosecution policy, which carries two dates but is in the same terms of October 2009 and April 2011. And states, quote, the decision to prosecute Royal Mail investigations in England and Wales will be reached in agreement between the Human Resources Director for the affected business unit or his or her nominated representative, the nominated representative from the investigation team, and the lawyer advising. The document at 5.5 addresses the process where there's no agreement between those people as to whether to prosecute or not. Did you identify that's obviously a change from the previous position?
Yes.
But did you identify an issue or concern with the policy being formulated in that way?
Well, it appeared on my reading of it to identify who the nominated representatives may have been in the earlier policies, which were not spelled out in those. But it did suggest that decisions as to prosecution would involve human resources amongst others, and that, again, it wasn't quite clear how the legal advice would factor in to that process. So those were the two areas that jumped out at me.
And was there any concern that a member of the investigation team would be a party to decision making on whether the suspect should have proceedings commenced against them?
Potentially, there's clearly no impediment to the investigation team having an input into the process by which a decision is made. It would be entirely normal, for example, for the police to provide report and to provide their assessment to the CPS before the CPS then made a decision as to prosecution. So that wouldn't be a problem. But here it does read as if the decision to prosecute is a collegiate matter with three parties, one of which is the investigation team, one of which is the lawyer, and one of which is HR. And that, certainly in my experience, is unusual. And the further stage, where there's disagreements, it's for the criminal law team and the investigation team heads to come to a decision as to what should be done.
And I think 5.5 envisages that HR are taken out of the process.
Yes.
Moving on to January 2011, the Royal Mail prosecution decision procedure provides at paragraph 4.4 that the regional human resources director, or in post office cases, the senior security manager, ... will act as the decision maker in authorising prosecutions or not. All decision makers will be familiar with the evidential and public interest tests of the Code for Crown Prosecutors and will make decisions accordingly. So this seemed to suggest that it was the security manager in post office limited cases who was the decision maker.
Yes, and so if I'm right in my reading of this in conjunction with other policies, it would therefore be the person with superintendence for the investigation process who would then make the prosecuting decision. and or, depending on the situation, the regional human resources director. And as I read it, that they would be tasked with understanding and applying the Code for Crown Prosecutors rather than being an independent legal assessment and decision.
And the comments you made earlier about assistance being needed for non-lawyers with the terms of and carrying into effect of the code apply here, do they?
Yes.
F, the Royal Mail prosecution decision procedure of January 2011 at 5.1-2 states, a criminal lawyer will advise whether the case papers meet the evidential test for prosecution and provide advice on the most appropriate action to be taken. The PSO will forward the relevant case papers to the appropriate decision maker for a decision on whether it's in the public interest to initiate a prosecution. What were the good or less than good points about this iteration of the policy?
Well, clearly it recognises the importance of a lawyer providing advice. There isn't a specific reference to the Code for Crown Prosecutors, but there is a reference to the test from it as to evidential sufficiency as opposed to the public interest test. And then the decision is taken by the decision maker. And this is 2011, so if this is read in conjunction with the policies above, then your decision maker is again either the person with superintendence for the investigation process or the director for HR. And so again, it's getting legal advice, but the decision then being made by someone else.
G, the Post Office Limited Criminal Enforcement and Prosecution Policy, which you understand to be dated November 2012, provides that decisions to proceed with a prosecution will be taken by the head of security of Post Office Limited upon legal advice. Was there any difficulty or concern with that?
Only that, again, trying to rationalise these policies with each other. The head of security had earlier been identified as being the superintendent of the investigation process. So again, it is the investigative arm that makes the decision as to whether to prosecute or not on advice, but an investigative, effectively, decision.
Thank you. Over the page to H, please. Moving forward to November 2013, so coming towards the end of the relevant period. The Post Office Prosecution Policy England and Wales, dated November 2013, in contrast to these earlier policies, stated that prosecution decisions should be taken by a qualified lawyer independent of any Post Office Limited department having a direct financial or other interest in prosecution. In a footnote, it added that this was designed to mirror the independence of CPS decisions.
And this is an important policy, this November 2013 policy. First, because of what I highlight here, which is that it is, I think I'm right in saying, the first policy that I identified where it was a lawyer making the decision on prosecution as opposed to others within the business. And secondly, this policy, in contrast to earlier policies, didn't just refer to the Code for Crown Prosecutors, but set out in some detail, in the way that the Code does, relevant factors, but Post Office specific factors that would inform both limbs of the test for prosecution.
And we'll be coming back to look at the way it does that when we come to
Yes.
charging decisions, which is a subtopic,
Yes.
probably tomorrow. I'm not going to deal with I and J because they are policies or documents that are either towards the end or outside of our period. But by this time, into 2014, did the Post Office policies change? So, for example, in the February 2014 policy, was it the case that rather than responsibility or accountability being shared across a number of individuals, the that policy proposed an individual within Post Office Limited to be appointed to take responsibility. And then in the December 2015 proposed policy, essentially recommendations being made on whether the decision should be to prosecute or not, but the General Counsel was the final decision maker.
Yeah, so I was a little concerned when I read the February 2014 discussion paper that it had appeared to me from the November 2013 policy that the question of who would make the decisions had been resolved. It was going to be a qualified lawyer independent of the Post Office, and then in February 2014 there was discussion about there being an identified individual. Clearly both were going in the right direction in terms of it being an independent decision of the business.
Is your overarching conclusion set out at paragraph 56 at the foot of the page?
Yes.
Namely, it follows that in the case of the Post Office, throughout the inquiry's relevant period, there was no such distinction of roles of investigator and prosecutor being undertaken by separate agencies, subject to separate oversight, governed by separate codes of practice, and with an inevitable role, the one keeping the other in check.
Yes. And again, as I think I said this morning, that doesn't have to be two entirely separate organisations, but it does have to be clearly defined teams within an organisation where it is clear which of them is ultimately making the decision. And ideally, that ought to be an independent lawyer, as it ended up being in 2013.
You say, as will be seen, there are aspects of the structure for disclosure under the Code of Practice issued under the CPIA and the guidelines issued by His Majesty's Attorney General that similarly seek to divide responsibility and create cross-referring superintendents of the disclosure regime between investigative agency on the one hand and the prosecuting agency on the other. Where those agencies are in fact the same agency, the need to ensure that no blurring of lines of responsibility and review becomes all the more important.
Yes.
You gave us an overview earlier on of this issue. Just to restate it, in relation to this point, the succession of policies which you examined and the absence of a distinction of roles, how can you calibrate your level of concern?
Certainly in the earlier part of the period for which I saw policies that identified who was responsible for making prosecution decisions, it was not clear that there was that independence and delineation of role, and that is, if I'm correct in that identification and understanding of the policy position, then that is a serious shortcoming.
Thank you. That can come down from the screen. Moving to a separate subtopic, the role of the prosecutor. You tell us in your report that the proper role of the prosecutor in the decisions that they take as to whether to charge in ensuring fair and proper disclosure in the proceedings and in the conduct of the proceedings more generally emerge from a succession of decisions of the court, in particular the Court of Appeal, from the Bar Code of Conduct and from the recommendations of the Farquharson Committee. Is that right?
Yes.
Dealing with that sort of trilogy of sources, can we start with decisions of the court? And I think we're at page 19 of your report on paragraph 37.
Yes.
So page 19, thank you. So this is the first set of sources that we're looking to, decision of the courts, as to the role of the prosecutor. And you take us to the decision of a Court of Appeal in Puddick. And I think that was a decision made in 1865, is that
It
right?
was, yes.
So quite some vintage. And Mr. Justice Compton told us that prosecution counsel, quote, are to regard themselves as ministers for justice and not to struggle for a conviction. And then moving on, the decision of, again, I think a Court of Appeal in Banks, which I think was a 1916 decision, or at least reported in that year. Mr. Justice Avery made similar observations. Quote, it's quite true that counsel for the prosecution throughout a case ought not to struggle for the verdict against a prisoner, but that they ought to bear themselves rather in the character of ministers of justice, assisting in the administration of justice. And in the remainder of that paragraph, you make a point that although the judges in one of those cases was addressing how prosecution counsel had expressed themselves in a closing speech, I think, the point is a broader one. By that, do you mean broader in that it involves other stages of the prosecutorial enterprise, charge, disclosure and the like, or that it applied to individuals other than counsel? Or both?
It certainly applied to counsel in a broader context just than the content of their closing speech. The concept of the prosecutor as a minister of justice, which is developed and has been developed since those references at the end of the 19th century and early into the 20th, in terms of them being independent and seeking always to put the proper administration of justice at the forefront of what they do, rather than it being the winning that matters. That is what those judges were talking about in those cases, and that is what that concept has reflected since then, and with a wider understanding as things have developed, that it's talking about the prosecution rather than just prosecution counsel as it's gone on.
So the answer is both. It's other parts of the prosecutorial enterprise,
yes,
and it's not just prosecution counsel.
Yes.
Thank you. The second source of the description of the duty acting as a minister of justice and all that involves, I think you say emerges from the Farquharson Committee of 1986, is that right?
Yes.
And you address that in paragraph 38 of your report.
Yes.
If we can just read that, please. Second line, you say the introductory paragraphs of the Farquharson report state, quote, there's no doubt that the obligations of prosecution counsel are different from those of counsel instructed for the defence in a criminal case or of counsel instructed in civil matters. His duties are wider, both to the court and to the public at large. Furthermore, having regard to his duty to present the case for the prosecution fairly to the jury, he has a greater independence of those instructing him than that enjoyed by other counsel. It's well known to every practitioner that counsel for the prosecution must conduct his case moderately, albeit firmly. He must not strive unfairly to obtain a conviction. He must not press his case beyond the limits which the evidence permits. He must not invite the jury to convict on evidence which is in his own judgment no longer sustains the charge laid in the indictment. If the evidence of a witness is undermined or severely blemished in the course of cross-examination, prosecution counsel must not present him to the jury as worthy of a credibility he no longer enjoys. Great responsibility is placed upon prosecution counsel, and although his description as a minister of justice may sound pompous to modern ears, it accurately describes the way in which he should discharge his function.
Yes.
I'm not going to read the summary of the Farquharson Committee's views in the propositions that you set out in paragraph 39, but instead can we turn to paragraph 40 on page 21. You tell us that these principles in relation to the duty of fairness and the application of the interests of justice to the prosecution and the prosecutor apply equally in a private prosecution. That's the headline point, is it?
Yes.
As was demonstrated in, for example, Zinger. And I think that's a 2014 decision of the then Lord Chief Justice, Lord Thomas,
Yes.
Mr. Justice Foskett and Mr. Justice Hickinbottom. And Lord Justice Thomas, the Lord Chief Justice, Lord Thomas, the Lord Chief Justice, said at paragraph 61, he was speaking for the court, quote, advocates and solicitors who have conduct of private prosecutions must observe the highest standards of integrity of regard for the public interest and duty to act as a minister of justice, as described by Mr. Justice Farquharson, in preference to the interests of the client who has instructed him to bring the prosecution. As Judge David, Queen's Counsel, a most eminent criminal justice, rightly said in the Maxwell case, in respect of a private prosecution, traditionally Crown Counsel owes a duty to the public and to the court to ensure that the proceeding is fair and in the overall public interest. The duty transcends the duty owed to the personal body that has instituted the proceedings and which prosecutes the indictment. And so, in short, the Farquharson principles encapsulated in that phrase that a prosecutor must act as a minister of justice are recognised to apply not just to public prosecutors but to private prosecutions and to advocates and solicitors conducting them.
Yes. And as with Kay that we looked at this morning, Lord Thomas was not saying anything new in 2014 in that regard, as, for example, his reference to the 1980 decision of Maxwell underlines.
Yes, and so that's not just a nice point being made on the common law when it's stated by a court is always been the common law. It's a different point that you're making, that this wasn't the first recognition of the application of the Farquharson principles to private prosecutors.
Absolutely.
It had been established, including in Maxwell.
Yes.
Can we turn to the role of independent counsel? That can come down from the screen, thank you. Would you agree that any barrister practising in criminal law, and particularly any barrister that prosecuted, ought to be aware of their Farquharson duties as independent ministers of justice?
Yes.
And would you expect any such counsel instructed to prosecute to review the evidence in the case and advise if they felt the evidence did not support the charge or the prosecution more generally?
Yes.
Would you agree that the Post Office was entitled to place reliance on the fact that the counsel that it instructed would exercise those degrees of independent scrutiny and advise accordingly?
Yes.
Of course, that depends on, does it not, the revelation of the material to that counsel to allow them to perform that function?
Yes.
Were you aware that the conduct of Post Office prosecutions was undertaken primarily by counsel instructed from the independent bar?
Yes. And certainly, now that I'm up to my neck in part two, I see that a lot.
And would you accept the proposition that, given that role of counsel and their instruction to prosecute for the Post Office, that was independent oversight of the Post Office's prosecutorial decisions?
It was a degree of independent oversight, but it very much would always depend on what was disclosed to counsel as part of the process to enable them to undertake that oversight.
Do you want to explain that in any more detail?
Well, clearly, if counsel were making the initial decision as to whether a charge should be brought or not, then they had an independent role at that stage. I have to say that the cases I've been looking at for Volume 2, that doesn't appear to be what was happening. That decisions were made in-house and then counsel were then instructed It would then be for counsel to advise on the evidence as it was presented to them, which would often involve them looking at the investigation report and that an assessment from the investigation and the evidence that was served upon them.
Just stopping there, Mr. Atkinson, have you seen many formal instructions to counsel to advise on evidence? And if that's a question too far at the moment, then we'll come back to it in volume 2.
I can think of, off the top of my head, 2 of the 20 that I've looked at so far where I've seen instructions at all. And I don't recall there being a specific request for advice on anything in particular. I have seen in some of the cases I looked at a degree of advice from counsel based on what they had been given.
Thank you. In terms of other forms of oversight, would you regard the Magistrates' Court as providing scrutiny and oversight of the Post Office's prosecutorial practices and decision-making because it could, in any particular case, refuse to issue a summons?
Clearly, the Magistrates' Court can refuse to issue a summons, but that is why the duty of candour to the Magistrates' Court is so important, because the Magistrates' Court can only fulfil that role properly if it is told not only that which underpins the allegation, but also anything that may count against the prosecution of that allegation. So, for example, if that prosecution would represent an abuse of process, there is a requirement that that is identified. And if that doesn't happen, then it's rather difficult to see how the Magistrates' Court can carry out any realistic oversight.
Would you regard the Crown Court, for those cases that reached the Crown Court, as providing supervision and oversight of the Post Office's prosecutorial practices and prosecution decision-making?
Again, it can fulfil that role, but again, it depends on that court being seized of the necessary information to undertake that process. So, for example, in the 20 cases that I've been looking at more recently, there was certainly at least one where there was an abuse of process application. There were a couple where there were applications for further disclosure pursuant to Section 8 of the CPIA, and that's after the defence have set out their case in a defence statement, they can submit to the court that there hasn't been proper disclosure to them as a result of that. And so those were occasions on which the Crown Court could have addressed those issues, but it clearly depended on what they were told in response.
And so there are occasions in the criminal process in the Crown Court where opportunities arise to test evidential sufficiency.
Yes.
So an application to dismiss or a half-time submission.
Yes.
There are occasions that arise where applications for disclosure can be made under Section 8, as you've just described, of the CPIA. Yes. Do they provide oversight and scrutiny of prosecutorial practices and prosecutorial decision-making?
Again, I think the answer is that they can do, but they very much depend on the prosecution approaching its role with that Minister of Justice hat squarely on, that the prosecution are making the court aware of the shortcomings of its case and the validity of any argument raised against it, so that the court can properly undertake its task. If the court is not put in possession of the facts, then it can't carry out an oversight of that which it doesn't know.
And to add to the obvious point that you've just made, courts are obviously only cited on a small part of the information that a prosecutor may be in possession of.
Yes, and so now where, as an illustration of that, where cases are served in a digital format and the court has access to the digital folder for the case, it will not often have access to the unused materials sections of that. And the same was the case ordinarily when things were served on paper, that the court would have the served case, not the unused material, that which was had been disclosed but was not part of the prosecution's evidence, and so wouldn't be able to carry out that kind of exercise for itself. It would need to be told that there was an issue and what the material was.
We're going to come to disclosure later, but just for those of us or those that are watching or listening that aren't aware of the distinction between the served case and the unused material, can you in a sentence or two explain what that is, please?
So I'll give it a go. The served case is the material that the prosecution rely on to prove its case and to establish, if all goes its way, the guilt of the accused. Other material that is in the prosecution's possession, which it has acquired during the course of the investigation and which may undermine its case or assist that of the defendant, ought to be disclosed to the defence, ought to be recorded in schedules of unused material. So it's wider material than that which is relied on and would be called before a jury, but which is nevertheless generated or acquired during the investigation.
And to add 2 points to the limitation of the oversight function, do courts proceed on the basis that prosecutions are being pursued competently and professionally in accordance with the Minister of Justice duties?
Yes.
And is there a limitation on oversight in cases where guilty pleas are entered, in particular at an early stage of the process?
Yes, and so if there is a charge before the court and the court is told the defendant is pleading guilty to it, it's unlikely the court would dig into the material to decide for itself whether the defendant was right to be doing that. They would rely on the parties to have reached that position responsibly.
Can we turn to motives for prosecuting pleas? And this is page 22 of your
Yes.
report at paragraph 44. If we can just read that together. In relation to the motivation of a private prosecutor, the approach of the Court of Appeal in Asif and Ditter, the decision's primary focus was as to whether the Crown Court judge had been entitled to stay proceedings brought by a private prosecutor as an abusive process, where satisfied that the proceedings were being brought by a proxy for a person with a significant background in fraud for collateral purposes or and for an improper motive. The Court of Appeal declined to interfere with the decision, observing, quote, "The court has the power to stay proceedings, ... where it will be impossible to give the accused a fair trial, and ... where it offends the court's sense of justice and propriety to be asked to try the accused in the particular circumstances of the case." On to paragraph 45. However, the court went on to observe that, quote, "It is well established that a private prosecutor can have another motive as well as being motivated by a public interest factor. Mixed motives are not of themselves a bar to a private prosecution. ... The question is where the line is to be drawn between the public interest motivation and the other oblique motive." The court cited in support of the latter observation the decision in ex parte South Coast Shipping Limited, a decision back in 1993. In that case, the challenge was unsuccessfully made to the bringing of a private prosecution by the bereaved family of one of those who died in the Martinez disaster. The fact that the family also wanted a public inquiry did not prevent such a prosecution. And then on to 46. That approach was also adopted by the Administrative Court in the Crown on the application of Smith-Allison against Westminster Magistrates Court, 2021 EWHC 231 admin, in which Mr. Justice Eadie observed at paragraph 48, quote, although a prosecution, whether public or private, must not be improperly motivated, the courts have recognised that in any private prosecution, a prosecutor will have a motive other than simply a desire that justice be done and that a criminal offence, if proven, should be punished. Ms. Justice Eadie carried on by citing from D Limited against A and others, in which Lord Justice Davis observed, quote, mixed motives may often be present in many prosecutions. In public prosecutions, the proceedings will be brought in the public interest, but the actual complaint may often be accused of, the complainant may be accused of, say, seeking revenge after a relationship has failed and so on. This may sometimes indeed be the case, but the true motive for the complainant may still be to seek justice. In a private prosecution, the complainant is, of course, frequently the prosecutor, but there too it is well established that mixed motives do not of themselves vitiate the prosecution. End quote. And so it's right, isn't it, that the law has established that whilst private prosecutors may properly have a mixed motive for bringing a prosecution, which won't vitiate their decision, that did not mean either that the Post Office was permitted to derogate from the need to make decisions on an objective basis, or that they could make decisions on the basis only of such motives.
No, absolutely.
Was there any evidence in any policy documents that you've seen of the criminal law team or its leadership being required to monitor prosecutions, for example, by dip sampling, in order to ascertain whether prosecutors were meeting their legal duties?
I can't think of any examples of that, no.
That prosecutors were applying the code test properly and diligently?
Again, this is perhaps slightly more a volume 2 question, and a question of whether the charging advices that I saw showed that. I think it would be difficult looking at them on their own to say that they did fully apply both limbs of the Code for Crown Prosecutors, particularly the public interest limb, which was regularly not addressed at all in the advices that I saw.
And sticking at the moment, sort of reining ourselves back into volumes 1 and 1A, in the policy documents that you saw, did you see any requirement of the criminal law team leadership being required to monitor or oversee whether prosecutors were applying the code tests properly?
Again, I can't think of any.
And, for example, whether they were making appropriate decisions about disclosure or non-disclosure?
In terms of monitoring that process,
Yes.
I can't think of examples of that.
Did you see any evidence on their face that the policies concerning the investigator's duties and the prosecutor's duties within the Post Office were themselves reviewed or audited by any external third parties, such as solicitors or barristers?
Clearly, as my report highlights, the various policies were updated at intervals. In the main, I don't think I saw any evidence as to why they were updated or who updated them or what had led them to do that. I think that the difference is, I think the 2013 policy that we touched on a little earlier, that clearly came about as a result of work that was undertaken by Cartwright King and from memory at that stage, Brian Altman, KC, as to their review of how prosecutions were being done, and those policies were the result of that. So there was that independent involvement at that stage, but I can't think of comparable evidence in relation to earlier policies.
Thank you. Can we turn, please, to the conduct of investigations?
Yes.
And you consider the conduct of investigations between paragraphs 57 to 117 of your report, and you go back to it at 366 to 370 of your report. Can we start, please, page 31, at paragraph 59. And you're here in paragraph 59, I think, referring to the power of the Secretary of State to issue codes of practice under the Police and Criminal Evidence Act, PACE 1984, in relation to the 6 topics or activities that you mention in A to F.
Yes.
These are all very well known, certainly to the chair of the inquiry. So I'm not going to look too much at the terms of the codes, nor to their statutory basis. Can we move on to paragraph 60, please? You say, in an approach similar to that intended to be achieved by section 26 of the CPIA, which is considered in more detail below, and which requires others involved in criminal investigations to have regard to the code issued under the CPIA, which sets out the manner in which investigators should record, retain and reveal to the prosecutor material obtained in a criminal investigation. Application of these PACE codes, that's the 6 codes you've identified, to investigators beyond the immediate ambit of PACE is achieved by section 67 of PACE. And so here you're drawing attention to the fact that the PACE codes of practice apply primarily to the conduct of the relevant activities by police officers.
Yes.
But by a statutory device, their reach is extended beyond police officers.
Yes.
And this is achieved by section 67, 9 to 11 of PACE.
Yes.
67.9 providing persons other than police officers who are charged with the duty of investigating offences or charging offenders shall, in the discharge of that duty, have regard to any relevant provision of such a code, and that's any one of the 6 codes.
Yes.
A failure on the part of ... any person other than a police officer who is charged with the duty of investigating offences or charging offenders to have regard to any relevant provision of such a code in the discharge of that duty shall not of itself render him liable to criminal or civil proceedings. But 11, in all criminal and civil proceedings, any such code shall be admissible in evidence, and if any provision of such code appears to the court or tribunal conducting the proceedings to be relevant to any question arising in the proceedings, it shall be taken into account in determining that question. And so what's the importance of these provisions in our present context?
It's recognised that whether a person other than a police officer is charged with the duty of investigating offences or charging offenders is a question of fact, depending on the circumstances. But it seemed to me, when I first started to approach this, that it would be difficult for the Post Office to argue that its investigation department was not charged with the duty of investigating offences, and therefore that it did fall within this and was therefore required to have regard to these codes. And in fairness, it was clear to me when I then looked at the Post Office policies that they accepted that and they recognised that.
They thought they did too.
Yes.
And so in general terms, your view would be that Post Office investigators were charged with the duty of investigating offences, and the Post Office recognise that themselves.
Yes.
And it would be your view that Post Office employees were charged with the responsibility of charging offenders with criminal offences.
Yes.
And the Post Office recognised that too.
Yes.
And so that means that there was a duty on each class of individual to have regard to any relevant provision of a code of practice when discharging those duties.
Yes. And that they recognise that courts that they would then be taking any such case to would be looking to them for their compliance or otherwise with those codes and the protections that they were designed to give.
So let's turn over the page to page 33 then and see what the Post Office policies tell us about what needs to be done to comply with PACE and in particular the codes of practice under PACE. I think that's your subheading there, Post
Yes.
Office policies relating to PACE and paragraph 64 onwards. And paragraph you say in the consignia investigation procedure of January 2001, there are limited references to PACE and the codes. Under inquiry methods at 3.3.1, the policy said the investigator should endeavour to ascertain the facts in an effort to solve the case. There's no compulsion to anyone involved unless it's considered to be necessary or expedient. Are there any difficulties or problems with that?
It is largely a statement of the obvious. It perhaps didn't assist as much as it could have done as to identifying when it would be necessary or expedient to question people. But that would be the only comment I'd make on that.
And so it's more what it doesn't say than what it does.
Yes.
At 3.1.2, the same document states investigations, collection of facts in accordance with the Police and Criminal Evidence Act and the other legislation. And you tell us no reference in the document to the application or otherwise of the codes in relation to arrest, search, seizure or interviews. Is that the problem that you identified with it?
Yes. The Police and Criminal Evidence Act is a vast doorstop of a piece of legislation, and it would not help someone looking at this on its own to know what that meant to them.
You turn to a different policy, but say that the same approach and the same comments apply, namely at your C, by your reference to the Post Office Rules and Standards policy issued in October 2000, which identify the investigators are bound by PACE and the codes without saying how.
Yes, so it was absolutely correct to identify that by reference to section 67.9 that they were bound by them or that they were to have regard to them. They went further than that, and that was a good thing. But then stopping short of giving them, the people who were going to be doing it, on the face of that policy, the necessary information as to what that meant to them. And it's of note, we'll come on to it, that was something that the Post Office developed a lot in their policies going forward from there. So clearly there was, as I see it, a recognition by them looking back that this wasn't enough.
And so is this an example, an early example, of what you described earlier, essentially name-checking an Act of Parliament?
Yes.
But not doing anything else?
Yes.
In paragraph 65, you note that within the October 2000 policy, there is a cross-reference to comprehensive training notes having been issued or to be issued. And I think by the time you wrote your report, you had been provided with the Security Foundation Programme Open Learning on PACE Codes of Practice workbook.
Yes.
Which you thought might be the cross-reference to the comprehensive notes. They set out the background to the codes, the areas addressed by each code, and then in slightly more detail, the relevance to a post office investigation of codes, B, searching, D, detention and C, detention and questioning, and E, tape recorded interviews.
Yes, and so it seemed to me that those training materials did provide a good deal more information as to which codes applied and how they applied, and they were talking about the codes that were the logical ones for them to be talking about.
However, in your paragraph 66, you identify 3 points for us, 3 problems. Can you see, first you say that the training notes do not amount to a comprehensive guide to how the code should be applied in an investigation by whom and to whom. Do you want to explain what you meant by that, please?
So they identified what the code was, what its purpose was, but didn't, it seemed to me, provide sufficient guidance to someone who was going to benefit from that training as to what then they were to do using that code, when they were to use it. And so it didn't, in and of itself, deal with the lack of information in the policies from that period of time as to how the codes were to be applied by investigators.
You make a second point that it wasn't adequate to expect those undertaking criminal inquiries, criminal investigations, to rely on notes given during a training session because, as you've made clear already, the statutory and policy framework inevitably alters, and such notes will be rendered out of date.
Yes.
You say in the last part of the paragraph there, further it can be properly argued. You use that formulation a number of times in there. When I'm speaking with my children, I sometimes use that formulation to make clear that I'm not entirely sure of my ground. Is that how I should read that, or is there something more definitive in your mind?
I think my concern was that I was conscious that I had not seen the full range of training material that was available. I became aware through my reading of what I was given that there was a database in existence which I had not seen, the contents of which I had not seen.
And I think that remains the position.
And that remains the position.
For you, both you and the inquiry.
Yes. And so it was difficult for me to be more clear-cut than that, not knowing what other sources of material were available that could be added to what I had seen in relation to, for example, the application of the PACE codes to investigators.
And so it could be that the most up-to-date versions of the CPIA codes, or indeed the PACE codes, were readily available in that database. You don't know one way or the other.
And that I have seen very recently some examples of circulars that appeared to have been generated by or in conjunction with that database that did, certainly from memory, include at least one occasion when the circular referred to an updated version of a particular PACE code, I think code G. And so on the face of that, there may be not only up-to-date versions of the code available to investigators, but they're being told, if they were the ones who were receiving the circulars, which again I don't know, may have been told that there was an up-to-date version. It has to be said that the circular that I'm talking about just said there is a new version of code G. It didn't tell anyone anything more than that.
Would you agree or disagree with the suggestion that it's not enough to have up-to-date codes of practice on a database, but instead the post office investigators and prosecutors needed to know from a policy what they had to access and how they should apply it in their circumstances?
It is a good thing, in my view, a good thing to have a database that has the up-to-date versions of applicable statutes, codes, guidelines available, but that is not a substitute for it being clear to, for example, an investigator that these are the things they have to apply, how they have to apply them, when they have to apply them, and how they can be satisfied that they've applied them properly. And so it's a part of the picture. It is not, in my view, a substitute for there being a policy that says these are the criteria you're meant to be applying in this situation by reference to Code C, and then they can understand which bits of Code C apply to them when, and they can check they're up to date then by looking at the database informed by the policy, but not one without the other.
What about the point that the codes of practice are generally drafted in a way that they make clear what's required of an investigator or a prosecutor on their face, that they're, because they're written in that kind of language, there was no need for such codes to be more than referred to in the policies themselves? They needn't be paraphrased or summarised or carried into effect in the policies. What do you say to that suggestion?
It's certainly right that the aim of the codes as drafted is to make them as accessible as possible. The difficulty with that, though, is that the PACE codes are primarily designed for use by police officers by reference to the powers of police officers, which are different in important respects from the powers of persons who aren't police officers, and therefore, as in fairness the Post Office recognised, there were powers available to police officers, duties that flowed from those for police officers that did not apply to them. And so simply to provide someone with a code, however clearly written, parts of which applied to them and parts of them which didn't, parts of which applied as written, parts of which applied in a slightly different way to them, would not be enough. They needed to understand the difference, and the difference came from policy being set out clearly for them against the background of training. It's the combination of the three that makes sure that someone, particularly someone who is not a police officer, knows how a police code applies to them.
Thank you, Mr. Atkinson. So it's 3 o'clock. I wonder whether we would take now the afternoon break until 3:15.
Yes, that's fine. Thank you.
Thank you very much. Sir, good afternoon. Can you see and hear me?
Yes, thank you.
Thank you very much. Mr. Atkinson, can we pick up a few questions where I left off? Would you accept the idea that there was an inherent value to the simplicity of the Post Office policies that we've seen, with detail being contained in Acts of Parliament, codes of practice, and other policy documents that were obtainable by investigators or prosecutors elsewhere?
No.
And why is that?
For the reasons that we were discussing before the break, it's if the aim is to achieve correct and consistent application of the law, it is not enough to tell people where it is. You need to tell them how they are meant to apply it. And there are different ways of doing that through training and through making those sources of law available to them, but also by telling them what parts of, for example, a vast Act of Parliament they're meant to be looking at, and how it applies to them and when it applies to them. And simply name checking is not going to do that, in my view.
Would you accept that the Police and Criminal Evidence Act, the CPIA, and the codes of practice issued under each of those acts were freely available online for anyone to go and look up?
Yes.
Is that sufficient?
No, and on my reading of the policies in relation to PACE, the Post Office clearly did not think it was sufficient because they developed their policies in relation to, for example, interviewing, so that by the end of the inquiry's period of particular concern, there was a raft of policies in relation to different contexts in which they might be interviewing different kinds of person about different things and how they were to do that. So it was clearly recognised it was not enough to have a policy that says if you're interviewing somebody, this is the code you need to read, and it's online. They recognised that, and in my view, they were right to recognise that.
Given that you accept that Post Office investigators receive some training in respect of the Police and Criminal Evidence Act and the CPIA that may have been relevant to their work, would you accept that they would therefore have known of the existence of the acts, the codes and the guidelines online, and therefore could have looked at them as and when required?
That there is, in my view, a significant difference on what I have seen between the degree of training in relation to the codes under the Police and Criminal Evidence Act on the one hand, and the CPIA and the codes under the CPIA on the other. I saw very limited material in relation to the latter. In relation to PACE, again, the training would clearly have been of value. Having the material online would have been on value, but in my view, and as it seems to me, was recognised ultimately, more was needed. And ultimately, more was given.
Given, as you said today, that training materials would not necessarily reflect the up-to-date amendments to codes and to guidance, wouldn't you therefore accept that there is great sense in not including the detail of the guidance in any of the policies, but instead to have the most up-to-date sources of law available in either a database or online?
The better approach, it would seem to me, would be that when a new version of the code came out, you updated your policy so that the two continued to run together, just as, for example, the Attorney General updates the Attorney General's guidance in relation to disclosure when the CPIA code changes, and just as the CPS has updated historically its disclosure manual, its code for Crown prosecutors, and its other guidance as the law has evolved. The law is never static, and policy needs to move with it rather than be so bare in its detail that it doesn't have to be.
Thank you. Can we turn to a new topic, please? The CPIA
Yes.
and the CPI Code of Practice. This is paragraph 76 of your report on page 39.
Thank you.
Page 39, thank you. Firstly, and in very general terms, can you explain to us what the CPIA is?
The Criminal Procedure and Investigations Act is an act that seeks to do a variety of things, but the key part of it for present purposes is that it sought to set out in statutory form the process and the stage process that was necessary in relation to disclosure in criminal proceedings. So going back to what we were talking about earlier, in addition to the service of the material that the prosecution was relying on as part of its case, what its duties were for the disclosure of wider material acquired during the investigation, and how that process was to operate with the involvement at relevant stages of input from the defence. And so the key sections are the early sections of the Act, which set out that stage disclosure process, and then section 23, which you can see referred to at paragraph 77 of my report, which was and is the key section that required the Secretary of State to prepare a code of practice for how that process was to be undertaken and what the interaction between investigator and prosecutor should be to ensure that process did happen and happen fairly.
Thank you. Is it right that some parts of the CPIA apply to proceedings commenced by the Post Office?
Yes.
And so that would include the disclosure obligations in Part 1 of the CPIA.
Yes.
Other parts of the CPIA apply only directly to criminal investigations undertaken by the police service.
Yes. And that is clear, for example, because it refers to police officers in various sections for that reason.
And I'm going to look at a more direct reason in a moment, just to nail that down as to why those parts only apply directly to police officers. Then we'll move on to how they apply indirectly to the Post Office. You set out for us, if we just scroll down, please, Section 23, which you've said is of fundamental importance of the CPIA. And you can see that it says that the Secretary of State shall prepare a code of practice containing provisions designed to secure that where a criminal investigation is conducted, and then it continues. You'll see the words where a criminal investigation is conducted there, yes?
Yes.
And I just want to examine whether those words, criminal investigation, are a term of art, a defined term. I think we have to look at Section 22 of the CPIA to establish that. And I think we'll have to look at the Act to find that. That is RLIT 6079. It's your tab C14.
Thank you.
RLIT 6079. $5079. Perfect. And if we can go to page, I think it's 15. Thank you. And it's the introductory section to Part 2 of the CPIA. And remember, I'd highlighted those words in 23(1)A, a criminal investigation. 22 provides, for the purposes of this part, a criminal investigation is an investigation conducted by police officers with a view to it being ascertained, etc.
Yes.
And so is that the first reason why the direct applicability of the code issued under Section 23 is only in relation to criminal investigations being conducted by police officers?
Yes, although interestingly, as we will see, the Post Office disclosure policies in 2001 and then in 2010 refer to that definition of a criminal investigation for the purposes of the Post Office as well.
Yes, albeit that's not in fact the statutory route
No.
by which they were required to have regard to
No,
it.
but it showed their recognition of what it was talking about.
Thank you. If we go back to your report, please, on page 40 at paragraph 78. Page 40, please. Paragraph 78. you say the CPIA goes on to address matters that the code may or may not address. The terms of the section make clear in doing so the code will only apply directly to the conduct of investigations by the police.
Yes.
And you've picked up the reference to police officer or police officers in other parts of section 23. So that's another reason making it clear
Yes.
of the direct application. You go on to say, if we go down to paragraph 80, that the application of the code issued under section 23 to the police is also made clear by the introduction to the code itself. And then you cite its introduction in paragraph 1.1-2. It, quote, applies in respect of criminal investigations conducted by police officers which begin on or after the day on which this code comes into effect. But then this, quote, persons other than police officers who are charged with the duty of conducting an investigation as defined in the Act are to have regard to the relevant provisions of this code and should take these into account in applying their own operating procedures. This code does not apply to persons who are not charged with the duty of conducting an investigation as defined in the Act. End quote. And you say this text appeared in the original 1997 version of the code and has been unaltered ever since.
Yes.
I think we need to look at section 69, sorry, section 67, subsection 9 of the CPIA. Can we first look at section 26? That's paragraph 81.
Yes.
And if we just look, rather than going back to the Act, the terms of the section 26(1), a person other than a police officer who's charged with the duty of conducting an investigation, with a view to it being ascertained whether a person should be charged with an offence or whether a person charged with an offence is guilty of it, shall in discharging that duty have regard to any relevant provision of a code which would apply if the investigation were conducted by police officers. So that's the application of the code on a have regard basis to non-police officers where they are charged with the duty of conducting relevant investigations.
Yes, and so it's that same wording as we saw in relation to section 67 of the Police and Criminal Evidence Act, the same have regard to.
And so the same device is used.
Yes.
And similarly in section 26(2, the breach not rendering such a person liable to criminal or civil proceedings, the same, but admissibility under section 26(3, the same too.
Yes.
And so that's the provision, is this right, which you say meant that the code, I'm going to use the word applied, to the post office.
Yes.
And it's a have regard to duty.
Yes.
Was there a different and more circuitous route to this too? Section 67(9) of PACE required investigators to have regard to Note 11B of Code C.
Yes.
And Note 11B of Code C says that the CPIA Code of Practice states that in conducting an investigation, the investigator should pursue all reasonable lines of inquiry, whether these point towards or away from the suspect. What is reasonable will depend on the particular circumstances. Interviewers should keep this in mind when deciding what questions to ask in an interview.
Yes.
So summarising there, that's a more circuitous route of the application to the post office of the reasonable lines of inquiry duty at the point of interview.
Yes.
Can we turn, please, to page 42 of your report, where you address the issue of the recognition of the CPIA and its duties in post office policies. In this paragraph and up to paragraph 92 of your report, on page 45, you identify the presence of bare references to the CPIA and its codes of practice and its code of practice in post office policies. Is that right?
Yes.
You identify the absence of any reference at all to the duty to pursue reasonable lines of inquiry.
I think until 2010.
And you identify the absence of guidance on what the duty means in practice and how it is to be achieved.
Yes.
You identify the limited reference in training material to the fact of the CPIA and its code.
Yes, and in that respect, there was a contrast between the material I saw in relation to PACE and the material I saw in relation to the CPIA. There was a lot more on PACE than there was on the CPIA.
And was a lot of that on PACE about the treatment of a suspect in interview?
Yes.
Was that the overwhelming majority?
It was the major topic, yes.
How to interview a suspect?
Yes. And in fairness, the other codes, for example, as to arrests and searches, the Post Office recognised that in that kind of area there was a lot of overlap between what actually they could or couldn't do and what the police therefore had to do in conjunction with them. And so that, whereas interviews were something they very much were doing themselves, so that did make sense.
Have you any views to offer as to the adequacy or otherwise of the treatment of the CPIA and the code in these policies?
So the two disclosure policies that were produced, the one in 2001 and the one in 2010, did give, or particularly the 2010 one, did give an overview structure of what the CPIA and its code required of an investigator and a prosecutor. So there was that material, but the absence from both of any detailed analysis of how other sources of information in relation to disclosure, such as the Attorney General's guidelines, was a concern, and we'll come back, I know, to that. The absence of a reference until 2010 of the requirement that an investigation pursue all reasonable lines of inquiry, including those leading away from the suspect, was, in my view, a fundamental omission. It is an important and, in some respects, counterintuitive requirement of a fair and proper investigation, that you don't just look for the evidence to prove your case, you look for the evidence that shows your case is wrong, and or that will afford a defendant a fair exploration of your case. And for that not to be mentioned for the majority of the inquiry's relevant period is a significant failure, in my view.
So the absence for a decade of a reference to the core duty was, have I understood it correctly, a particularly striking failure?
Yes, and it's telling, in my view, that when one looks at Section 23 and what it was the Secretary of State was required to prepare a code to address, the first thing that it was meant to address was reasonable steps being taken for the purposes of the investigation and all reasonable lines of inquiry being pursued. So it was identified from the outset as being a fundamentally important thing. And so for that to be a feature of the Act, a feature of the Code, but not a feature of the policy that was seeking to apply the Code to the Post Office, it is a real concern.
If we just turn to page 45, please, and look at paragraph 92. And it's the last 4 lines. You say, if it is proper to argue that the limitations of PACE-related policies had to be balanced by the extent of PACE-related training, which is not an argument with which I agree for the reasons developed above, then the same argument cannot be made in relation to the CPIA.
Yes.
Can you just explain what you mean by that, please?
Because on the material I saw, there was so little training material in relation to the CPIA and its code. If it were to be argued, what we did was we had a policy that identified that the Act existed, that the code existed, and that people needed to know that they existed. We then provided them with training so that they understood how they applied to them, and we had them online up to date. That was an argument that you could make, but with the problems that I've identified in relation to PACE, but you can't make on what I have seen in relation to the CPIA because the training just wasn't there on what I saw. And again, I haven't seen the database, and there is that qualification.
Thank you. Can we turn, please, to paragraph 106 of your report on page 50? It's about halfway down. Thank you. Under the cross-heading, the application of the CPIA code by the Post Office. You tell us in 106 that it's of note that the Post Office Disclosure of Unused Material, Criminal Procedure and Investigations Act 1996 Code of Practice Policy, issued in May 2001, defines a criminal investigation in line with the CPIA definition. Is that the point you were making just a few minutes ago? It says at paragraph 3.1, it's an investigation, quote, with a view to ascertaining whether a person should be charged with a criminal offence or if charged with an offence is guilty of it. The same wording appeared in later policies of 2009, 11, 12, 13, and also appeared in the policy on disclosure of unused material in July 2010. And so is the point that you're making in 106, if I got it right, that these policies all define a post office criminal investigation in a way that triggers the duties in the way that we've seen in section 26 of the CPIA?
Yes.
Good. Paragraph 107, please. You tell us the Disclosure of Unused Material Criminal Procedure and Investigations Act 1996 Code of Practice Policy was issued in May 2001, and it addresses the roles of the investigator and the disclosure officer without specific cross-reference to the CPIA code. It's 3 pages long. The essential points in terms of roles are, and then you set out the role over the page, of an investigator being someone involved in the conduct of a criminal investigation who has a duty in particular to record and retain information. They share a duty with the disclosure officer to be fair and objective and must work together with prosecutors to ensure that disclosure obligations are met. And the disclosure officer is the person responsible for examining material retained during an investigation, revealing material to legal services during the investigation, and certifying to legal services that he has done this. In contrast, arguably, to the CPIA code, the policy proceeds on the basis that the investigator and disclosure officer will normally be the same person. So in paragraph 107, more generally, what are the points that you are making as to the existence of satisfactory provisions and unsatisfactory provisions?
And so this 2001 policy had the basic structure and with one obvious exception, that the key areas of the CPIA in relation to disclosure and the code in relation to disclosure set out. And so, for example, both the Act and the code focus very much on what I've characterised as the 3 R's, the duties to record, retain and review information. And it correctly set out those matters. It set out what the roles were in relation to those. It did so in a fairly bare bones way, but in relation to those areas it covered, it would allow for a degree of interaction in a useful way between someone reading the policy and someone reading the code that underpinned the policy. It gave them steers on most, but unfortunately not all, the key areas that applied to them.
Just on the 3 R's, is the third R review or reveal?
It's reveal, you're quite right, yes.
Thank you. Any other issues in relation to arising from paragraph 107?
The other area in relation to that is that the code and the Act identify as separate roles that of investigator and disclosure officer. And they're identified as separate roles because they are separate jobs with separate responsibilities. It's recognised in the codes that those can be undertaken by the same person, and I am aware that particularly in smaller police investigations, they are undertaken by the same person. But there was a difference, which I therefore highlighted, that the Post Office policy identified that they would normally be undertaken by the same person rather than they could be undertaken by the same person.
Thank you. Paragraph 108, please. This is another in the line of Post Office policies that fails. Is this right to identify what needs to be done?
It again identified the roles. It again identified that they would normally be undertaken by the same person, but without any of the surrounding detail as to what that actually meant. And if the same person is to undertake both roles, there was perhaps a greater need for exactly what that meant and how it was to be done to be spelt out.
The consignia investigation procedure of January 2001, you tell us in paragraph 109, makes limited references to the CPIA and the codes issued thereunder. It refers to circumstances in which records relating to surveillance equipment should be retained, see paragraph 3.2, and the retention of notebooks in compliance with CPIA retention periods, see paragraph 3.3. It does not explicitly seek to mesh with the Disclosure of Unused Material, Criminal Procedures and Investigations Act 1996 Codes of Practice policy. And you say it's of note that the training materials relating to notebooks that appear to have been in use at this period of time by reference to the copyright date of 2000 do not refer to the duty of retention, the CPIA, or even this 2001 policy document.
Yes, so it was really the point I make there is the lack of cross-reference, and someone charged with an investigative duty reading the investigative procedure is not being told in that procedure that they have also to apply a separate policy and which has a wider ambit of implications for them as an investigator than the investigation procedure alone would have told them.
If we can read through paragraph 110 together, please. You tell us that the Post Office Limited financial investigation policy in the May 2010 version made no specific reference to the CPIA or the code issued thereunder, although it did identify as an aim, see paragraph 3.1, adherence to UK and EU legislation. Is that sufficient to say we must adhere to UK and EU legislation in a policy of this kind?
It's a commendable aim, but there's an awful lot of it. And it might have helped more if they'd specified which bits they had in mind for adherence in this context.
You continue, the revision to this policy in February 2011 added a procedures and standards section which identified adherence with the CPIA. It was silent as to the manner in which this was to be achieved, save for adding that financial investigators should, quote, ensure that all investigations are recorded correctly in a timely manner. And similarly, the casework management policy at paragraph 3.3 enjoined team leaders should ensure all avenues of inquiry have been exhausted, but it does not spell out that this involves lines of inquiry leading away from the suspect as well as to implicate them.
Yes.
I think you've, in explaining the policy, set out the problems with them as you've gone along there.
Yes.
Is that right? Is there anything you want to add to
No, thank you.
110? Paragraph 111, you tell us that there are some acknowledgements of the 3 Rs. You've just explained those to us, to be found in the post office policies that you had considered, albeit they're limited and far from comprehensive. In the investigation procedures of January 2011, it states at paragraph 3.2, quote, local records may be required as evidence or unused material. If so, they must be kept in accordance with the Post Office Codes of Practice under the CPIA. And in relation to notebooks, paragraph 3.3, where used in evidence, notebooks must be retained in compliance with the retention periods set out in the Post Office Codes of Practice under the CPIA. You say, I've not seen the code to which this refers, but the Post Office Code of Conduct of Criminal Investigations policy of August 2013 states in relation to the duty to record, quote, it is important to document every action, decision and reason for decisions being made during the course of an investigation. That policy also noted, quote, all activities undertaken during an investigation should be recorded on the event log. And so here you're addressing the extent to which post office policies over the years acknowledged or even referred to the 3 Rs.
Yes.
And you say they're limited and far from comprehensive. Again, could you help us by calibrating the level of concern, if any, that you have about this?
Well, my level of concern may rather depend on what the Post Office Code of Practice under the CPIA was. If it was the Disclosure of Unused Material, Criminal Procedure and Investigation Act 1996 Codes of Practice that was issued in May 2001, then that would, by the cross-reference, ensure that someone approaching their duty to record the various matters set out here would also have understood how that meshed with the CPIA. If it's not that, then I haven't seen it. It's certainly not got the same name as the document I've just referred to, which may not help. So my level of concern would very much depend on whether they're talking about a cross-reference to the CPIA procedure or not. If they are, then the position is perhaps less concerning than it would be otherwise. But really what I've done here is identify occasions when the duty to record is given in specific examples. Giving the specific examples is a good thing, but helping people to understand why they're meant to be doing it and what they're going to do with it later in terms of disclosure and revelation to the prosecutor would make it a more effective process.
If it assists, I don't think we still have a document that's entitled Post Office Code of Practice under the CPIA. Moving on to paragraph 112, you tell us that 2013 policy, that's the Post Office Conduct of Criminal Investigations policy of August 2013, is
yes.
that right? Did address the supervision and conduct of a criminal investigation. Under heading, it said, the decided course of action needs to be proportionate and necessary. It may, if circumstances warrant, be more appropriate to consider other actions that could be done and don't necessarily lead to a criminal investigation. Proper consistent supervision is vital to ensure that cases are thoroughly investigated and submitted in a timely manner. Team leaders, with the support of financial investigators, need to quality assure the investigation to make sure prior to initial submission that all available evidence has been gathered. And then it continued. If we scroll down to 113, please. It continued, it's important to consider the aims, objectives and scope of the investigation. The security manager is required to prepare an investigation plan which will outline the terms of reference in the way the investigation was conducted. It made reference to the standard of proof which was necessary in criminal investigations, including those which involve material from the Horizon system, and stated the security manager has been tasked to prove or dispel the allegation. In criminal cases where the burden of proof is beyond reasonable doubt, it's necessary to draw on all available evidence, which is necessary to draw on all available evidence which is likely to substantiate the allegation. In cases concerning the Horizon system, it's important to establish the level of training the suspect received, when this was received, and the action the subject took to remedy any identified faults. A key point to cover template has been produced to ensure that security managers establish these facts during the interview process. Sources of evidence to be collated were then identified. You make a number of points on this even August 2013 policy, right at the end of the relevant period in your paragraph 114. You tell us that there was some recognition at looking away from, looking at material that led away from a suspect.
Yes.
Is that the line? It may, if the circumstances warrant, be more appropriate to consider other actions that could be done and don't necessarily lead to a criminal investigation.
It's also the reference to the security manager being tasked to prove or dispel the allegation, so looking both at that which helps establish a case and that which undermines it.
But you say that was only a passing observation.
Yes.
It was without explanation as to the implications. What do you mean without explanation as to the implications?
It was just those words that the security manager has been tasked to prove or dispel the allegation. It would, in my view, have made that clearer if they were referred to the words of the CPIA code test, namely that they should pursue all reasonable lines of inquiry that lead towards and away from the suspect, or the wording of the CPIA in that respect, so that it is clearer what that involves them doing.
You say that you're going to consider paragraph 5.59 in a moment, which we will, but you say the focus of 5.57 was on the strengthening of the case against the suspect, rather than identifying whether he might be correctly suspected or not.
Yes, and so having said prove or dispel the allegation, it then goes on to talk about all available evidence which is necessary to substantiate the allegation.
And so it's giving with one hand but taking away with the other.
Yes.
And then when it mentions Horizon, is it right that the policy said that in cases concerning Horizon, one must refocus one's attention on the training given to the suspect?
Yes.
And what he, the suspect, did to remedy a fault?
Yes.
You tell us in B that there was no reference to the consideration of or investigation of or disclosure of anything that might suggest a failure in the operation of the system, as opposed to failures by the suspect.
Yes, so it was focused on the operator, not the system that they were seeking to operate.
And did that remain the case in the 2014 issue?
Yes.
And did that remain the case in the 2018 edition? Yes. Albeit, I think you tell us that Horizon was identified as a specific interview topic.
Yes.
And so, did you have any concerns or observations on this, the specific mention of what's called a Horizon-related investigation or cases concerning the Horizon system, but focusing attention back on the suspect?
The potential concern there was that in a case where the evidence was Horizon dependent, the focus would still be on whether the person operating the system had had the training to use it with a view to establishing that they therefore should have been able to operate it correctly, rather than any consideration of whether, despite their training, there was an issue that was beyond their control in relation to the reliability of the evidence from the system. And so it's rather was borne out in some of the material I saw for the purposes of Volume 2 that there was questioning in interview about training. There was the obtaining of evidence in relation to training in relation to Horizon, with a view to establishing that they should have been able to work the system properly, with the then conclusion potentially being drawn that therefore it couldn't have been a user error, it must have been a deliberate action by the user that something had gone wrong, but without considering the other possibility that was always potentially there, namely that there was a problem with the system, not them.
Are you aware of any high-profile cases concerning prosecutions by the CPS where it transpires that information contained on the Police National Computer, the PNC, had been used in support of prosecutions but was incorrect?
No. That's not to say that there weren't any, but I'm not aware of them.
Thank you. Can we?
There certainly weren't any cases prosecuted by me.
Yes, very good. Can we turn to paragraph 115, please, which is on page 54.
Yes, thank you.
Which you promised to come back to in a moment. Earlier in your report, you say that 5.5.9, this is again still the August 2013 policy, states, quote, the security manager must not overlook the fact that a fair investigation is there to establish the truth as well as substantiate the allegation. So it's important that any evidence uncovered that may support the subject's position is also recovered. It's important to document every action, decision and reason for decisions being made during the course of the investigation. You say that that paragraph reflects 3.4 of the CPIA code and the need to consider evidence that exonerates as well as implicates. You say that it is of note that it was in what appears to be the 2018 reviewed and amended version of this policy, that the need for schedules of unuse was addressed.
Yes. And so the point I'm making is that whilst I had identified limitations to the references to the duty to pursue all reasonable lines of inquiry, including those leading away from the suspect at paragraph 5.5.7 of this policy, that balance was moved back towards a proper appreciation of what that duty was by paragraph 5.5.9. So someone reading the two would be in a better position to understand what was required of them than someone just reading the first of those.
You say similarly in paragraph 116, the July 2010 revision of the Royal Mail disclosure of unused material policy did expressly state under the heading duties of investigators and disclosure officers at paragraph 3.2, investigators must pursue all reasonable lines of inquiry, whether these point towards or away from the suspect.
Yes.
Is that the anchoring of the point you've made a couple of times already? It's not until July 2010
Yes.
that we actually see the core duty reflected in the documents that you've seen.
Absolutely.
What is reasonable in each case will depend on the particular circumstances. For example, where material is held on a computer, it will be a matter for the investigator to decide which material on the computer it is reasonable to inquire into and in what manner. That policy replicates the definitions of material and relevance set out in the code and then addresses the 3 R's, retention, recording and revelation.
Yes.
Just in terms of the reference to material being held on a computer, it's a matter for the investigator to decide what material on that computer is reasonable to inquire into and in what manner. Have you any observation to make in relation to the quality and extent of that guidance in cases which are founded upon data produced by a computer?
What I think that sentence is intended to replicate, because the 2010 policy was designed to give effect to the 2005 Attorney General's guidelines, amongst other things, was the recognition that disclosure obligations in relation to the content of a computer did require an assessment of what was proportionate to identify in interrogating the computer and how you were going to do that and what involvement there would be from the defence, which was something that was built on by subsequent Attorney General's guidelines in 2011 and 2013. So I think that's the context there for that, rather than it having any reference to the assessment of the reliability of computer data as a potential line of inquiry.
Thank you. Moving on to paragraph 117. You say that the November 2013 Post Office prosecution policy, England and Wales, addressed disclosure in a more detailed manner, more akin to comparable CPS documents. So it's by this time, the end of the period we're looking at, that one sees some convergence. Is that right?
Yes.
It states at paragraph 6.2, Post Office Limited will take all reasonable steps to identify and record material which may meet the test for disclosure, making specific reference to CPIA section 3 in a footnote. In doing so, the Post Office will operate a continuous process designed to identify any material, whether the subject of a criminal investigation or not, which may relate to the integrity and reliability of Post Office Limited's IT and data systems. Is that the first reference you've seen in policies which recognises the need to identify material that concerns the integrity and reliability of the Post Office's data systems?
Yes, certainly from recollection, I think that's right.
And that's November 13.
Yes.
In keeping with this more detailed consideration of disclosure in 2013, there's evidence of training that specifically addressed disclosure in November 2012, which included an introduction to the, quote, principles of disclosure, the role of the disclosure officer, the types of material that fell to be considered, and the schedules that were required to address the disclosure exercise. And thereafter, a set of training slides for a presentation of principles of disclosure was prepared in 2015, February, in similar terms. However, you point out neither could be described as comprehensive or sufficient in themselves to ensure CPIA compliance.
Yes.
And why do you say that?
They are, as with other training material that I've seen, they are clearly useful and they clearly will help, but it wouldn't be enough to provide someone with a set of training slides. Going forward, they would need to have a more comprehensive policy of the kind that the 2013 policy in many respects was. And so the point I'm making is the training in and of itself was not enough. You needed the policy as well. That was a position that was achieved in a much more thorough and satisfactory way from 2013 onwards, and in stark contrast to the position before that.
Standing back, that can come down from the screen, thank you. What are your views on the adequacy or otherwise of this suite of policies insofar as the CPIA and the code issued under it are concerned from an investigator's perspective?
The policy from 2001 onwards did give a correct and in many respects helpful overview of what was required and who it was required to do what. But the omission of the duty in relation to all reasonable lines of inquiry was an important omission. The lack of reference to the types of lines of inquiry that ought to be considered, like that of the integrity and reliability of data systems, which finally found its place in 2013, again, was an omission. And so the earlier policy documents were helpful insofar as they went, but they did not, in my view, equip investigators properly to appreciate what their duties as investigators were in the fundamental respect of looking for material that exonerated as well as implicated a suspect.
On the core duty, the reasonable lines of inquiry duty, given the centrality of it in section 23(1), do you think it can be said that because it was so obvious from section 23(1), that it follows that investigators must have known about it?
That would, I suppose, that the process would then be that they receive their training, although I've seen very limited material in relation to what that training would have covered or not, and so whether it would have covered that fundamental duty or not. They would have received the 2001 policy that made no reference to it and would have not led them to consider that aspect of the code as necessarily being one that applied to them, and so it would have required them to then look beyond the policy, identify there was something in the code that was not addressed in the policy, identified that despite that it applied to them, and to have applied it, rather than to have considered that the policy told them which bits of the CPIA and its code applied to them, and just look at those.
Was there anything in any of the policy documents that you have read that suggested to an investigator what they should do if a suspect raised the operation of the Horizon system as a possible explanation for losses during their interview under caution?
I think the short answer to that question is no. They could have understood from the policy that they were required to disclose material that undermined the prosecution case, and therefore if they had ready access to that, to material that did that and supported the defence case in that respect, then they ought to have disclosed it. Given the lack of more than the barest of reference in the 2001 policy to the Attorney General's guideline, they may not have appreciated, just by reference to that they were under a duty to address that third-party material in relation to that topic. And so there's an outside chance that they might have realised that they needed to pursue that if it was raised by someone in interview, but equally a chance that they wouldn't.
If they had failed to do so, would you consider that the prosecutor, and by that I mean a lawyer reviewing whether there was sufficient evidence to charge or not, or a lawyer in fact having conduct of a prosecution post charge, to have advised that lines of inquiry should be pursued if a suspect had raised the operation of the Horizon system as being an explanation for shortfalls shown in their accounts?
So a prosecutor reading and understanding the CPIA code and the code for Crown prosecutors in each of the various iterations of both of those would have understood, or should have understood, that they were under an obligation to consider whether there were lines of inquiry that ought to be pursued, that the content of a suspect's interview would highlight such lines of inquiry, and so applying those, they should have, where it was raised in an interview, raised the question as to whether that had been investigated or not, and if not, that it should be. But that would require them to be looking at those codes rather than at any post office policy that specifically was telling them that that's what they ought to do.
Can we turn to paragraph 141 of your report, please? Which is on page 67.
Thank you.
I'm taking things slightly out of order here because we're going to come back to charging decisions tomorrow. It's just a point on the contents of the October 2018 iteration
Yes.
of the Code of Crown Prosecutors. And in the third sentence, you say, or the third line, you say the full code test should be applied, paragraph 4.3, quote, when all outstanding reasonable lines of inquiry have been pursued or prior to the investigation being completed, if the prosecutor is satisfied that any further evidence or material is unlikely to affect the application of the full code test, whether in favour of or against a prosecution. Is it right that those qualifications there, the introduction of the cross-reference to all outstanding reasonable lines of inquiry have been pursued, appeared for the first time in the 2018 edition
Yes.
of the Code of Practice?
Yes.
And similarly, if we look at paragraph 146 of your report, which is at the foot of page 68, you cite paragraph 4.8 of the Code for Crown Prosecutors, and you say it follows the reliability of the evidence is identified as being a central consideration, together with the question of, quote, whether there is any material that may affect the assessment of the sufficiency of evidence, including examined and unexamined material in the possession of the police, and material that may be obtained through further reasonable lines of inquiry. Is that an addition?
That wording is, yes, in 2018. It's right to say that the requirement for the reviewing lawyer to provide advice as to lines of inquiry and the need for further evidence was always and had been for certainly throughout the inquiries period had always been an aspect of the code. So that wording was new in 2018. The role of a prosecutor in identifying evidential deficiencies, lines of inquiry that should be pursued, was not new in 2018, and certainly had appeared in the versions of the code that I have identified from 2004 onwards.
Thank you. And then lastly, before we break, if we just turn to paragraph 151 on page 70. You cite paragraph 3.6 of the code, quote, review is a continuing process and prosecutors must take account of any change in circumstances that occurs as the case develops. This includes what becomes known of the defence case, any further reasonable lines of inquiry that should be pursued, and receipt of any unused material that may undermine the prosecution case or assist the defence case to the extent that charges should be altered or discontinued or the prosecution should not proceed. Is that also a 2018 addition?
Yes and no is the answer to that. The continuing process of review and the need to take account of changes in circumstances as the case develops is a wording that did appear in the earlier versions of the code. The further specific reference to the defence case and what that gave rise to, that was the new bit.
Thank you very much. So if it's convenient to you, it's convenient to me, that's a break. We move next to charging decisions.
Yes, that's fine, Mr. Beer. It's been a long and interesting, from my point of view, day. Thank you very much, Mr. Atkinson, for the clarity of your answers and the economy of words used. I take it you won't want to be told not to speak to anyone about your evidence, since I can't imagine you'll want to. But if by chance there is any reason why you should speak to anyone, then let Mr. Beer know, who'll consult with his colleagues about what would be appropriate for you to do, all right?
Yes, thank you very much, sir.
Thank you, sir. So it's 10 o'clock tomorrow, please.
Fine, thank you.